Hail to legal warriors. When somebody gets arrested for a domestic violence crime, they're often ordered out of their home. In this video, I'm going to cover what someone in that situation needs to know and practically how they can live their life when they're dealing with this situation. So if you find this area of the law interesting, or if you're in the situation, stay tuned because this is the video for you. My name is Attorney Lance Fryrear, and I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years. I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people will get the help they need. Now I'm just going to jump right into it. The situation that I'm describing here is somebody gets arrested for a crime, and typically domestic violence, assault in the 4th degree, and when they get released from jail, there's a no contact order issued. And let's face it, most of the time, probably 80% plus of the time, a domestic violence case involves people that were living together. Boyfriend, girlfriend, husband, wife, son, father, brother and sister who live under the same roof. And the court is going to order that the defendant have no contact with the alleged victim. And why that doesn't seem like such a big deal, it is a big deal because almost always that's going to order the person out of their own home. And most of us can't just go rent somewhere else to live. Most of us don't have friends where we could, sleep on their couch for the next 90 to 180 days while this case goes on. So what do we do? What do we do in this situation? I'm going to cover some of the things that I get asked in doing this forever, and hopefully it will help you if you're in this situation. Sometimes we get asked, hey, can the alleged victim move out and I move into the house? There could be lots of reasons for that, right? Maybe the restrained party, the defendant, is the primary caretaker of the kids, and it makes more sense for the primary caretaker of the kids to be at home, and it's less inconvenient for the alleged victim to live somewhere else. They've got family or something like that. So usually the no contact order restricts someone from the residence of the victim. Most no contact orders don't say you cannot go to this certain address. They just check a box, residence of the victim. For the most part, that means that yes, in most cases, the alleged victim would be able to move out of the home if that's no longer the alleged victim's residence, and the victim gets to choose what his or her residence is. The court doesn't get to do that for them. If that's no longer their residence, then the restrained party, the defendant, would be able to move in. Now, you need to talk to your attorney because even if it's legally correct, it doesn't necessarily mean the particular court or prosecutor will see it that way. So there's things your attorney can do to give you some backup and some insurance. However, the answer that I'm telling you is, for the most part, the orders restrict residence of the victim, and the court doesn't get to say where the victim lives. So that's one thing that we see. Sometimes you can move back home if the victim changes their home, if that's what's convenient. Well, what's another question we have about living once you have a no contact order? Well, how do I get my stuff? Right? I've got yanked out of my home because of this incident. All I've got is my cell phone and the clothes on my back. I've got to go to work. I need my work computer. I need my work tools. What do I do? Well, let's hope that your attorney and the no contact order had authorized a civil standby. A civil standby is the court telling the police department that for one time only, with the police, with the defendant's going to be allowed to go to the restrained party's home, and because it was also the defendant's home, to get some stuff that they need to live. Personal effects, essential items. You can't get the TV off the wall or the couch, and the nicer you are to the police officer, maybe the longer they're going to give you. But you can get some clothes and some toiletries and maybe some, tools of the trade, your computer, maybe some other tools. And you need to follow the instructions for that jurisdiction. But for the most part, what happens, you're supposed to call the police, the non-emergency number, most of the time, sometimes 911, of the city where you live, or the law enforcement agency where you live. If it's unincorporated, it might be a sheriff. If it's in the city police officers, and say, hey, I've got a civil standby order. Can an officer help me? And then you work with them. You go to the site. Don't talk to the protected party, obviously, and get as much stuff as you can. So to get your stuff to live, That's what's supposed to happen. Well, Lance, what if I can't get everything I need and the protected party, the victim, wants me to have the stuff? Can't I just go there? Not legally, you can't. You can't go there on your own because that would violate the order. Well, what am I supposed to do? Well, you might be able to get, carefully, a third party to get your stuff for you. Now, let's be careful here. Most no contact orders, if not all of them, prohibit third party contact. And we say that's a term of art. Third party contact to us means, and hopefully to most people in the system means, telling the third party to pass a message on to the protected person, to the victim. You know, tell Miss Victim that I love her. That's third party contact. That's illegal. If your friend shows up and says, hey, Miss Victim, would you mind if I picked up Mr. Defendant's stuff because there's some stuff I think he needs? Well, that didn't pass a message from the defendant on. You're just trying to help, and the court doesn't have any power to restrain that third party. If the third party wants to volunteer to help, they can. And if the alleged victim wants to give the stuff to that person, they can. So if you have someone who's willing to cooperate in that way, and it's your belief through the grapevine that this other person, the alleged victim, is cooperative, that's a great way and to get things that you need, because we're trying to just triage and deal with the situation as it exists. In the long run, what you're going to want to do to try to get back home legally is you want to do some stuff typically. You want to do some classes and do some things like that. So if the protected party, the alleged victim, makes a motion to drop the no contact order, the court can look at you and says, oh, I've seen you've done some stuff. There's a reason to change the order because I'm in a different circumstance. Look what a good job the defendant's done. Originally, even if the victim doesn't want an order, the court will typically issue it just for the court's own reasons, to protect the court, to protect the victim, that type of stuff. So these are the situations. Of course, you can rent a place, you can sleep on someone's couch if you want. I'm dealing with the situations that seem more complicated where, hey, can I go live at home if they change their residence? Probably yes. How do I get my stuff, and how do I get more stuff than is allowed by the civil standby? So if you found this useful, please like and please subscribe. More people will get the help they need. And more importantly, if you have a criminal problem, feel free to reach out to my firm. We've been doing this more than 20 years. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.